On the phone, it is a pleasure to welcome from ThinkProgress Legal, Ian Millhiser. Ian, what's your official title over there?
I'm the editor of ThinkProgress Justice.
ThinkProgress Justice, and author of your book came out just a couple of months ago.
That's right, yeah, last March.
And we have a link to that book. It's Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. We have a link to that at majority.fm. So, Ian, we were just saying off air, it is a rare occasion where we have a term where we can largely celebrate what this court has done.
Yeah, no, it's a very surprising sensation. I've been covering the Roberts Court for a really long time, and I have never felt this way at the end of a term. It wasn't all good news. I mean, we just lost a bad death penalty case today. There's another case they handed down today that knocks out some rules that prevent mercury poisoning, or mercury pollution, so we all have mercury poisoning to look forward to now. But, for the most part, we got marriage equality, which is the rare case where the Roberts Court actually makes the law better than it was before they started. And then, on the Affordable Care Act, on redistricting, on, a lot of big issues, they could have done a tremendous amount of damage, and they decided, no, we're not going to ruin everything this time.
All right, let's go down these cases. I want to start with the EPA one, and then we'll touch on King V Burwell. King V Burwell is one of those cases where it just strikes me as in the plaintiff losing, there's like the case might as well have never happened. There's like absolutely not much that happens from that, and that's not the same with other cases. But let's just start with this EPA case because,
sure.
If I'm not mistaken, what happened in this case is the rules that the EPA set out based upon the Clean Air Act. They developed a set of rules to basically make sure that mercury, as you say, which has been proven to be a neurological toxin, particularly for young children, would not spew into the air. And Scalia basically wrote, and there was a 5-4 ruling in this, that the EPA did not examine the cost of the regulation that they promulgated at the right time in the process of promulgating that regulation. Wow. Where in the Constitution do we find that? Because I know how important this is to Scalia.
Right. Well, I mean, this was a statutory case. It dealt with what the law requires the EPA to do before it can regulate mercury in this way. And this case is really the reason why people hate lawyers, or, it points to the reason why people hate lawyers. Because the court did not say that the EPA cannot regulate mercury, nor did they say that the court reached the wrong conclusion when it set out the particular regulation that it handed down. What they said is that at a particular point in the long process that EPA has to go through whenever they promulgate a regulation, they didn't take into account a particular thing that they needed to consider at a particular time. So what's going to happen is that the EPA is going to go back and they're going to consider these costs at the time that they have to consider them, and they're eventually going to reach the exact same conclusion, and then we'll have the mercury regulations again, except for two things. One is that, it'll be that many more months or years while mercury pollution is still happening. And the second will be what happens if the Supreme Court runs out the clock. Because what could happen, of course, is that this could run out the clock until we have a different president in 2017. And if that president is less concerned about the earth than Barack Obama is, then we may have no mercury rules at all.
Now, we should say, though, on the flip side of that is from a practical standpoint, the fact that the regulations were contemplated for so long already changed the behavior of a lot of these coal plants. And so in many respects, it would be more costly for some of these plants to go back to where they were pre the writing and contemplation that these regulations were going to be adopted.
Right. No, and that's a good point. That a lot of plants, knowing that this was coming, have already changed the way they operate. They've already put in place new systems, and now they need to decide, like, okay, in order to compete with the plants that didn't do that, do I need to roll things back? That's going to cost me even more money. I think what a lot of them are going to be doing is they're going to be following the election returns very closely. They're going to be following the polls very closely because once again, one thing that this EPA decision does is it ups the stakes of this election even more, where yet another thing that's now at stake is whether or not we're going to have mercury poisoning.
Is there is there going to be a vestige here of anything? In other words, there's nothing sort of structural, it seems to me, that has changed. I mean, the EPA could go into this and as far as I understand it, they didn't look at the cost of regulating the cost. They didn't do a cost benefit analysis of regulating just mercury. What they did is they created these regulations. They then saw that once you create a system where mercury is no longer spewing into the air, there's a bunch of other toxins that will no longer be spewing into the air. And they calculated the value of those other toxins as well, which would be sort of byproducts of the original intent of this regulation. And that's when they did their cost benefit analysis, right? And so that's the only thing that's they got to go back and just look specifically at mercury, I guess, and or change the nature of the regulations. Is that it?
Yeah, I mean, I think this is primarily just a procedural holding. It's saying that, EPA didn't jump through the right hoops on the way to making this rule, and so now it has to go back and jump through those hoops again. Again with the caveat. Well, I guess I should add another caveat. I mean, one is the one I've already said, which is that a lot of this will depend on who's president when these regulations are finalized. But the other thing is, of course, given the Supreme Court that we have, there isn't anything from preventing them from coming back a few years from now when the regulation is reissued and saying, oh, I'm sorry, there's this other hoop.
Right. So, I mean, this is just basically them playing four corners on some level, but being down at the end of the game, I guess, in some way, and just hoping something changes. All right. Well, let's all right. So let's go back to last week. Let's start with King V Burwell. This holding for the plaintiff in this situation could have had devastating impact. But with the government winning, we're just back to this is obvious where we should have been, right?
Yeah, I mean, King V Burwell was the weakest case I have ever seen reach the Supreme Court. The plaintiff's argument in this case is that you can take one sentence of the Affordable Care Act completely out of context and read that sentence in order to destroy the way that the law is obviously supposed to operate. And actually, one thing that it's fascinating to me about the way the court handled it is that Chief Justice Roberts showed some real annoyance in his opinion. He actually left Obamacare's opponents in a worse position than they would be in if they had never brought this lawsuit, because he included this language in his opinion about how the purpose of the Affordable Care Act is to improve insurance markets, not to destroy them, and all judges need to interpret the law in that light. So that's going to make it harder to challenge the Affordable Care Act in the future. I think the reason why Roberts did that is because, as conservative as he is, I think he viewed this case as what it was, which was a vicious, partisan effort to get the Supreme Court to repeal a law that they couldn't repeal through the legitimate political process. And I think he wanted to deliver, a bit of a spanking to them so that they understand that this is not the way it's supposed to work.
The King v. Burwell was settled, was decided 6-3 with Kennedy and Roberts joining Kagan, Sotomayor, Ginsburg, and Breyer.
Mm-hmm.
So are we correct in assuming that it was Thomas, Alito, and Scalia who basically granted cert basically allowed this case to be heard. And so was Roberts also, tell me if that assumption is correct. And
Right.
does that basically mean that Roberts was also sort of like saying, like, guys, grow up here. Let's not waste our time?
Yeah, I mean, it's a good question about who granted cert. So, it takes 4 justices for the Supreme Court to agree to hear a case.
Oh.
And, but it takes 5 to actually decide the case. So one of the big mysteries here is when the case was actually handed down, there are only 3 justices who voted to kill Obamacare. Who's the 4th who agreed to take this case? And, I could think of a number of theories for that. I think it's possible that Kennedy voted to take the case, and then he flipped after he read the briefs and realized how weak the plaintiff's arguments were. It's also possible, the petition that the plaintiff filed asking the court to hear the case was all about uncertainty and how disruptive it would be for no one to know whether these subsidies are legal or not. So the Supreme Court better step in soon and answer that question. And so, maybe the Supreme Court wasn't acting politically when they took the case and they just decided to resolve that uncertainty. But, it's a big mystery. And, the most likely outcome is it looks like at least 4 justices took the case thinking they were going to kill Obamacare. And then at least one of them said, oh, yeah, no, I'm not going to do this.
And it doesn't sound like that one was Roberts, right? I mean, based upon that, what he's written there.
Yeah, Roberts really seems not the least bit happy with this suit. And in oral arguments as well, he was surprisingly quiet during oral arguments. He occasionally jumped in to throw a brief quip at something that someone was saying. But, now that we know the outcome, when I think back to what happened in oral argument, he almost seemed like, a hipster who was sitting there being like, I am so over this. He just seems exasperated that he had to sit through the whole thing.
Yeah, it's fascinating, but that really, in that dynamic that you're talking about there with Roberts comes into play in his dissent in the marriage equality case, and I want to get to that after we talk about the case itself, because obviously this is a big deal to be. I feel like it's a big deal to be. I've been alive at other times of other big cases, but sort of more conscious. I'm not 6, literally. But in this case, tell us on what grounds the Oberfeld. I can't say it. Case.
Oberfell, I think is how it's pronounced,
okay.
Although I'm actually not sure about that.
All right, so the Oberfell case, we know what we're talking about, marriage equality case. It was 5-4. On what grounds had the plaintiffs, tell us what case the plaintiffs had brought.
Sure. So, there's, broadly speaking, there's 2 different ways that this case could have gone. One is to say that there's some sort of a freestanding right to marriage protected by the Constitution, and that includes the right for gay people to get married. The other way they could have decided it is to say that this is rooted in equality, and that you can't discriminate against gay people in this way. And the Supreme Court mostly leaned on the first of those 2 options. They said there's a fundamental right to marriage, that right is big enough to encompass same-sex couples, and so denying them their fundamental right violates the Constitution.
Now, I just want to tease something out. Both those concepts come from the 14th Amendment, right?
That's correct. Yeah.
Okay,
both of them are implicit.
So let's, because I really want to tease this out, because this is fascinating. This is a big part of your piece. That I think, I think people would really enjoy knowing, because there is that concept within the 14th Amendment that has cut both ways for liberals. Back in the Lochner era, it didn't. But, arguably under Roe v. Wade, it did. Just tease that out for us.
Sure. So, the theory that Justice Kennedy used in his opinion is known as substantive due process, which is not something that I'm particularly fond of. So the Constitution says that no one shall be denied liberty without due process of law. And the court at the time said that what that means is that there are substantive rights that are encompassed in the word liberty, and the court's not allowed to take those rights away. And and in the past, they've at times used this to do really terrible things. The paradigmatic example of this is the Lochner decision, which held that basically laws that try to protect workers will be treated with great constitutional skepticism. And, that was used to strike down minimum wage laws, to strike down the right to organize, a lot of terrible stuff.
Child labor laws?
Child labor laws were struck down a different way, through a different theory. But, it was part of the same concept that this early 20th century court had, that we just, it shouldn't be the job of government to regulate the workplace.
And so just to put a fine point on it, justices at that time found this concept of freedom of contract came out of this sort of unenumerated liberty, right? That was just sort of like a freedom of contract is the child of this notion of liberty that is in the 14th Amendment.
Yeah, that's exactly right. And they used it. They didn't strike down every workplace law, but they struck down many very important workplace laws. So this is the theory that Kennedy used. And before anyone thinks that I'm dissing marriage equality, or that I'm dissing Roe v. Wade, which was also done under the substantive due process theory, both of those is a strong argument, especially in the case of marriage equality, that discriminating against gay people, discriminating against women, violates the Constitution's equal protection clause, the guarantee that people need to be treated equally. There's a law professor's debate to be had here over, what the best way to reach this decision was, and for various reasons, I think the best way to do it was by just saying, look, it's discrimination to deny gay people equal rights, and you can't do that.
I have to say that when the ruling came down, that's what my presumption was. It was that part of the 14th Amendment, because government is sitting here, and government doesn't necessarily. According to Kennedy's opinion, it's like the government is necessarily should be in the business of marriage because it is a fundamental right, as opposed to the idea of like, all right, government chose to be in the marriage business, which meant we're going to accord special rights to people who are married. And there's that list of whatever it is, 1,000 rights that you're available to you if you're married. And then the other part of the 14th Amendment would be like, well, if we're going to allow some people to engage in marriage to get these rights, we have to allow everybody to engage in that. Right.
No, that's exactly right. And so that brings me, I guess, to Roberts' dissent, which is really interesting and in an unexpected way, a huge defeat for the far right in this country. So, I mentioned that this notion of substantive due process has been used in the past to strike down workplace protections, basically to implement a libertarian economic policy. And there's a lot of folks who are growing very influential in the legal community who want to bring that back. In the conservative Federalist Society, that's now becoming the dominant notion, that we should return to a world where the court forces us to live in a libertarian society, whether anyone wants it or not. And Roberts' dissent attacks the approach that Kennedy used. It attacks his discussion of fundamental rights, but in the process, it describes the whole endeavor of using this method in order to implement economic policy as completely unacceptable. They use the word discredited to describe the seminal Lochner opinion that set this in place. And so even though, Roberts didn't vote the right way on marriage equality, in the process of saying no to marriage equality, he delivered a second spanking to the far right in this country. He said to his friends in the conservative legal community, look, You need to stop trying to fight in the courts battles that you want to fight that should be fought in the legislature. And if you can't win it, at least many of these battles through the democratic process, tough, you lose.
I mean, that's pretty stunning, right? I mean, that is more than anything. That's, I think, why we are starting to hear this sort of intense vitriol towards Roberts, because he has. I mean, I think Roberts would say, like, I didn't leave the Federalist Society. The Federalist Society left me, right?
Yes. No, I think that's exactly right. I mean, what's really going on here is this, is up until 2009, there was a broad consensus amongst Democrats and Republicans around the notion that judicial restraint is the rule and judicial activism is the exception. So, liberals wanted the courts to be more active on subjects like reproductive freedom. Conservatives wanted the courts to be more active on doing things like striking down racial justice laws. But for the most part, both liberals and conservatives agreed that in most cases, decisions should be made by the elected branches and not by the Supreme Court. And then something happened on January 20th, 2009. That changed conservatives' view of this. And as soon as Obama started governing, they suddenly decided that they really wanted the courts to step in and implement their agenda after all. So what I think Roberts is signaling, both with his King opinion and with his marriage equality dissent, is he's signaling that, look, I'm going to give you everything you asked for up until 2009. Like all that crazy stuff you want to do on race, all that stuff you want to do on campaign finance, all of that, it's yours. But I'm not going to roll us back to the 19th century. I'm not going to say that economic policy is the domain of the Supreme Court. And so that means all of these new big demands that the Federalist Society started making in the last 6 or 7 years, they ain't going to get it.
So he is willing to inhibit the power of government to regulate business, though, right? I mean, it's when I look at things like the Voting Rights Act, right? He's
right.
They really did a number on that, and we'll get to Scalia in a moment, because I can't even. It's impossible for me to reconcile how Scalia can complain about 5 judges in robes and,
right.
When he would write stuff like the Senate didn't have the guts to not reauthorize the Voting Rights Act, so we have
right.
to. Right? I mean, I'm paraphrasing, but I don't think it's too far from the truth. Or let's stop the voting in Florida, that type of thing. But so... where is that line? He's simply saying that I'm not going to promote this notion of Lochner. Like, I'm not going to find those rights in the 14th Amendment. Is that basically the line? And that constitutes a huge line for particularly the rights agenda or new agenda, or is it broader than that?
So here's where I think the line is in the Reagan administration. Roberts was very much part of the conservative faction within the Reagan Justice Department, and then later within the Reagan White House. And this was a faction that was skeptical of the Voting Rights Act, was skeptical of most efforts to enact legislation to promote racial justice. That it would allow, some forms of civil rights laws, but not many. It was generally skeptical of efforts to use the Constitution to protect the equality of groups on bases other than race. They laid out the things that they didn't, the areas of law that they wanted to change. But they also said, look, we do not believe that the Constitution authorizes, that courts should be enforcing what are called unenumerated rights, that they should be enforcing rights that aren't specifically named in the Constitution. What has happened in the last 6 or 7 years is that conservative lawyers are no longer asking for the court to implement a short laundry list of things like what they've been asking for since the Reagan administration. they've been asking the courts to implement the entire Republican Party platform via the judiciary, via judicial fiat. And, it's small comfort to the people who relied on the Voting Rights Act that, Roberts is willing to go that far and no farther. But this is a really meaningful limit that he's articulating here. He's saying that there is a stopping point where he's going to say, I'm sorry, guys, you've gotten all you're going to get out of me. And he's saying that at a time when folks in the Federalist Society, folks on popular legal blogs, and attorneys bringing cases to his court are very aggressively asking him to implement a very conservative economic agenda.
So what's in the pipeline that you've seen in the pipeline that seems to be something that would cross that line?
Well, I think most of the challenges, the remaining challenges to the Affordable Care Act, he's probably just going to say, nah, I'm not being your partisan monkey here. I think a lot of what he said, it's not that there's something currently in the pipeline right now that we now think it's going to go the other way. It's that I think this is going to act as a deterrent, where people aren't going to file as many, some aggressive suit asking the Supreme Court to implement some libertarian theory of economic liberty, because they now know that they're going to lose.
But I imagine, right? I mean, the Federalist Society and I don't know, whoever it is, they get together and they say, here's one we should try and challenge. Let's go out and look for some plaintiffs on this. And maybe that's just not that well broadcast, and maybe you don't need that much lead time. But I imagine sort of there's the equivalent of Evan Wolfson's, paper from 1983, right? There's that floating around out there on the right for this is how we're going to dismantle Social Security. This is how we're going to dismantle.
Yeah, they've written all kinds of books about it. You can buy them. So here's the thing. I mean, what this does is, even more so than the EPA decision we were discussing before, this massively increases the stakes for the next election. Because what you're seeing, if you read the influential conservative thinkers right now, or if you look at what prominent Federalist Society members are saying, they are saying that they are mad at Roberts, that they think that Bush screwed up when he put Roberts on the court. And, they want to make sure that the next Republican appointee is a more reliable conservative. One, like Jonathan Adler, one of the law professors who was behind the King V Burwell case, he specifically named Senator Mike Lee as someone that he'd like to see on the Supreme Court.
Jesus.
And Mike Lee thinks that Social Security is unconstitutional.
Right.
Mike Lee thinks that child labor laws are unconstitutional. He's a nut.
Right. That's Janice Brown, right? Is that her name? She's
Janice Rogers Brown, the D.C. Circuit. I mean, she's fortunately probably too old now to be a Supreme Court nominee. But I mean, someone like Mike Lee, he's fairly young. I believe he's in his 40s. And he, if he got on the Supreme Court, he would make Justice Thomas look like Karl Marx.
Wow.
I mean, really, really radical individual. And so what this changes is that, in the Bush administration, the Federalist Society was one of the, their executive vice president was one of George Bush's primary advisors on judicial nominations. What the conservative legal community was telling George W. Bush was that they wanted people like John Roberts. And now it looks like they're going to start telling, whoever if they have a favorable president, they're going to tell that person they want people like Mike Lee. That is a massive, scary shift, because it means that, the next Supreme Court fight, isn't going to be just about abortion, or isn't just going to be about the Affordable Care Act. It's going to be about whether we can have a regulatory state and a welfare state anymore.
Do you have a sense of there was also, I guess, just today, the Supreme Court denied I guess, to grant or to hear a case that would have allowed states to require evidence of citizenship when people explain to us what that case was.
Yeah, I mean, I wouldn't read too much into the Supreme Court's decision not to hear a case.
Okay.
I mean, often, it could be for a variety of reasons, some of them strategic. But yeah, I think that immigration is likely to reach the court in the next term. I think that the case that's likely to come up is, of course, there's the challenge to Obama's recently announced deportation policy. Right now, that's for the Fifth Circuit. The Fifth Circuit just announced the panel of judges who will hear it, and it is an awful panel. I mean, as bad as it could be. So the administration is going to lose in the Fifth Circuit, and that means they have to go up to the Supreme Court.
What else? What else struck you from this term as being, it sounds like aside from the rulings that we've talked about today and the implications, and I guess even the dissent that Roberts wrote in the marriage equality case. I mean, what else is that the biggest theme that comes out of this Supreme Court term for you? Is that Roberts has basically said, like, guys, you got to chill out a little bit.
Right. Well, there's that, and then the other thing that surprised me is that Kennedy has drawn a real distinction between himself and the other four conservatives on race. So, there was a case that sought to just really nuke the Federal Fair Housing Act, render, many fair housing laws completely unworkable, which would have led to a whole lot more race discrimination in housing. Most people thought that the good guys were going to lose that case. It was something that the justices have shown a lot of interest in taking up. And Kennedy wound up blinking in the end and joining the liberals to uphold the Fair Housing Act, as it's always been read by every federal appeals court in the country. So there is a real divide between Kennedy and the other four conservatives on race that will save at least some civil rights law. Now, what I don't think it's going to save is that the court announced today that it will hear the Fisher case, which is a case seeking to end affirmative action. And on that issue, I think that Kennedy's probably going to vote with the conservatives. Now,
getting back to the federal fair housing case for a moment, that case basically said that that it's not just something is discriminatory, not just if it is intended to be, but in terms of it having a disparate impact, right?
Right.
That you can measure what a policy does, and if its outcome creates discrimination or is discriminatory, that's enough as opposed to the intent.
Well, okay, so what that case held is that, generally speaking, there's two ways you can prove discrimination. One is, it's called disparate treatment, and it typically involves, you have to find a smoking gun document proving that someone had racist intent. So, if someone fires someone because they're black, and then they toss off an email to their colleagues saying, yes, I chose not to hire this person because I do not want to work with a black person, then that, you can produce that email in court and you're going to win because it shows that there's discriminatory intent. That's hard to do. The other way that you can win, and this is this disparate impact theory, is that if you could show that there's an anomaly in that an institution's hiring policies, that its lending policies, whatever, creates a weird racial anomaly that shouldn't exist, then you can bring them into court and force them to at least explain why it's there. And if they don't have a good explanation, they lose. So, if there are 30 or say there's 300 applicants for 50 job positions, and half of those applicants are black, but no black people get hired, if you look at those numbers and you think something's going wrong there, so you can take those numbers, you can bring the people into court, and they might have an explanation for it. It may turn out that coincidentally all the white people who applied had master's degrees and all the black people didn't, and they wanted someone with a master's degree. That's fine. But they have to at least explain themselves. And if they can't explain themselves, then they lose.
So with disparate impact intact as a measure, will that implicate at all the Voting Rights Act or no? I mean, it seems to me, right, that will that have any implication on, like, I guess, like Section 2 of the Voting Rights Act?
Well, I mean, it certainly matters because Section 2 of the Voting Rights Act does allow disparate impact suits when it comes to voting discrimination, something that Roberts opposed, by the way, when he was in the Reagan administration. So, the fact that Kennedy wasn't willing to blow it up in one context is a hopeful sign that he won't blow it up in another context.
Okay, so it at least it in some ways it protects what could have been a vulnerable part of the Voting Rights Act.
That's right.
Okay, and all right, and anything we should be looking forward to in the coming term, or won't we know for a while?
It's going to be a big term, and I doubt very much that next term is going to be one where liberals do as well. There's going to be this affirmative action case. There's probably going to be a big union case that's going to go very badly, and chances are they'll take an abortion case as well.
Wow. All right. Well, Ian Millhiser, I really appreciate your time today. We'll put a link up to your book, Injustices, and thanks so much for coming on.